Welcome to the recorded version of HIPAA Regulations and Sharing Sensitive Information About Clients with Dementia from September 27, 2017, part of the National Alzheimer's and Dementia Resource Center webinar series sponsored by the Administration for Community Living. At this point, I would like to turn the floor over to Sari Schumann, who is going to moderate and give us some more information here today. So welcome, Sari.
Thanks, Steve. Welcome, everyone, to the webinar today on HIPAA regulations and sharing sensitive information about clients with dementia. In this webinar series, the Administration for Community Living's National Alzheimer's and Dementia Resource Center has partnered with the American Society on Aging. We're pleased to have all of you in attendance today. And before we start, Erin Long of the Administration for Community Living will provide a brief welcome. Erin?
Hi, everyone. I'd like to thank you for taking time out of your busy schedules to join us at this webinar on this very important topic. I want to thank Charlie and Rachel for sharing their wisdom with us. And with that, I will give it back to you, Sari, so we can get things rolling.
Thanks, Erin. For today's webinar, we'll hear from Rachel Seeger, who is the Senior Advisor for Public Affairs and Outreach at the Office for Civil Rights in the United States Department of Health and Human Services, and has been there since 1999 working on HIPAA rules for the Department of Health and Human Services. Charlie Sabatino is the Director of the American Bar Association's Commission on Law and Aging, where since 1984, as a senior attorney and then as director, he has been responsible for the ABA Commission's policy research, project development, policy consultations, and education in areas of health law, long-term care, guardianship and capacity issues, surrogate decision-making, and legal service delivery to older persons. Without further ado, I'm going to turn it over to Rachel and Charlie for their presentations. Thank you so much both for being here today.
Thank you, Sari. I'm going to start off with a prefatory remark about dementia and HIPAA issues, which are probably obvious to most of the audience. But HIPAA being, for our perspective today, a privacy rule, capacity issues are a key issue because HIPAA is premised on client ability to control their information and to consent to disclosure when they want to. Dementia obviously makes capacity questions come up frequently, and they're not always addressed very clearly in these kinds of situations compared to when you look at when advanced directives, for example, become effective. Most state laws have specific provisions in them for a procedure for determining capacity and documenting it. HIPAA issues come up much more often on the fly, so capacity questions can sometimes people's capacity can be overlooked when they do have capacity to consent. Other times when they don't, you might find resistance because a provider says, well, they have to consent when they're clearly not able to. But anyway, you have to keep that in mind. Secondly, reliance on representatives and other interested parties becomes more common in terms of discussion and disclosure of information. And that's really what we're going to focus upon here today, when and how that can be done. And then, of course, when there are no representatives or natural family or friends, then healthcare providers are in a situation where they're trying to identify family members or friends or significant others who can help provide information about the patient. And that's really where their discretion to disclose information is stretched to the limit, because they may be trying to investigate who would be the proper person to talk to, and in doing that, they may have to decide what they can disclose and what they can't. So it can be a tough decision in many respects. Now, what we're going to do here today is I'm going to, in terms of our organization, is cover a few key concepts in the Act and regulations and give an overview of pathways for disclosure. And then Rachel Seeger is going to go more into depth on the kinds of circumstances where these disclosure issues come up and give you examples. And then she'll end with talking about some of the resources that are available from the Office of Civil Rights for you all and for others on your rights under HIPAA. So let's get going with some basic concepts. This starting with the HIPAA Act itself, the Health Insurance Portability and Accountability Act of 1996. Under that act, there have been four major rules: the privacy rule, which is what we're focusing on today, but there's also a security rule and a breach notification rule and an enforcement rule. And since 2013, the regulations have been put into what's often referred to as the omnibus rule, which you'll sometimes hear people refer to. That was mandated by the HITECH Act, which is the Health Information Technology for Economic and Clinical Health Act. So these are terms you may hear: the omnibus rule, the HITECH Act, and that was changed because of the Affordable Care Act. So there's a lot of different authorities that interact with each other. But our focus is basically going to be on the privacy rule and rights and obligations underneath it. Starting concept is the notion of a covered entity. HIPAA doesn't apply to you unless, one, you're a covered entity, and that's a healthcare provider, and it could be any of these things listed on the slide, who furnish, bill, or receive payment for healthcare in the normal course of business, but only if they transmit any information in an electronic form in connection with a transaction, which HHS has standards for, which are generally transactions having to do with coverage and payment. So theoretically, a social worker, for example, in private practice, who doesn't accept any insurance and only accepts cash payments from clients, wouldn't be covered by HIPAA if that's really the only extent of their work in terms of billing clients. The other covered entities include health plans, and these are kind of the usual range of suspects: health insurance companies, HMOs, the government programs of Medicare and Medicaid, veterans health care programs. They are all covered entities. And then thirdly, healthcare clearinghouses, which are nothing that's particularly relevant to the audience here today, but they process non-standard health information, which means basic identifiable health information that they receive from another entity. Another key concept is individually identifiable health information, and that's any information, demographic data that relates to past, present, or future health care conditions: physical health, provision of health, payments for the provision of health, that identifies the individual, or for which there is a reasonable basis to believe it can be used to identify the individual. So that includes descriptive information of many common identifiers, the obvious ones being name and address and birth date, but even, as this slide says, even your weight can be a descriptive identifier that would distinguish who you are individually. So it's a very broad definition. Now, the most central concept under the Act is of that identifiable health information. It's really protected health information that is the key of the key concept of the privacy rule, and that's individually identifiable health information that is transmitted by electronic media or maintained in electronic media or transmitted or maintained in any other form or medium. And this information is protected and must be kept private except under the terms that the Act permits. And many of the standard disclosures that don't need permission have to do with the operation of the healthcare system, getting your, identifying that you have insurance coverage, having the insurance coverage pay for it. So there are many, many disclosures which the healthcare providers don't have to ask you for, but they basically ensure that the delivery of health care and payment for it can take place within the governmental standards. Now, there are exceptions even with protected healthcare information that can always come up, particularly in the kinds of situations you all deal with. Disclosures about victims of abuse, neglect, or domestic violence, or disclosures to avert a serious threat to health and safety are permitted under the Act. And conversely, where disclosures are permitted to other individuals, that information can be kept when providers have a suspicion of that person being involved in abuse or violence against the patient. So practically everything we say here today has variations and exceptions to it, so you always have to keep that in mind. And finally, the concept and definition of personal representative is explicit in the rule. This is a person who has authority to act on behalf of an individual, an adult or emancipated minor, who we're talking about, in making decisions related to health care. This very clearly includes one who's named as an agent under health care power of attorney, one who is legally authorized under a default surrogate state law. Now, most states do have in their health decisions statutes a default surrogate law, which says if you haven't named anybody and there's no guardian, then usually these authorize an order of next of kin to be permitted to access information and to give consent on behalf of the patient or withhold consent, starting with spouse, adult child, and they're written in very different ways, but they're generally following next of kin. But some states don't have this provision, so there would be fewer people who have standing as a personal representative. And finally, a guardian with health decisions authority, and I would underline with health decisions authority, because just because someone is appointed a guardian doesn't mean that they have health decisions authority, or if they have it, it may be limited. You really have to look at the guardianship order in order to know that. Sometimes people will be named as conservator is the most common term used for one who has authority over one's estate. And just because one has that title, a provider may think, well, they have access to information. That would not be correct. In either case, you have to look at the order, which is often not done, which can be a problem. So a covered entity must, with some exceptions, treat the personal representative as the individual for purposes of the privacy rule. So they have the same right to access the information and right to give permission for disclosures as that individual would, if that individual lacks the capacity to make those decisions for himself or herself. Okay, now let me summarize HIPAA disclosure pathways, the ways that disclosure is permitted, and we're generally talking about disclosure to individuals, families, and friends. One, if the recipient is the personal representative, then as I already told you, they have a right to access that information and to talk to the doc and others involved with the delivery of care. Two, there's a written HIPAA authorization. Three, there's a written right of access direction form. And four, there are certain disclosures that are discretionary. We're going to talk about each of these throughout the rest of our program. So this is the one, again, that I've already mentioned, but I really want to emphasize this because it underlies the importance of encouraging people to do advanced care planning well ahead of time and to name a healthcare agent or proxy and have that on record, because then there is really little question, absent that person being a suspected abuser, of having access to information. To HIPAA authorizations, you all have probably signed more than one of these, because every time you go to a new doctor or provider, they give you a HIPAA disclosure form and have you sign an authorization. And usually these forms have a line for it that who is someone, your spouse or someone else, that they can disclose information to. They don't necessarily have that, but most of them that I've encountered do. And that gives the provider authority to share information with whoever you name there. They usually only ask for one person, so it's limited. And this is really a permission. This isn't a mandate. It is a permission. Thirdly, is the right of access that individuals have under HIPAA, which I still find being the most unknown aspect of HIPAA. The rule mandates release, absent special circumstances we've talked to, if a right of access direction is given. It should be in writing, signed by the individual, and identify the designated person. And if you're talking about records being given to the person where to send the copy of the protected health information. So there's no prescribed form in the rule. There is for HIPAA authorizations. They're very specific. It tells what has to be in those, but there's no particular prescribed form. So because of this coming up so many times, we, in my program, devised a sample form, which you can't read very well on the slide, but I think it's part of the materials, and if it isn't, we'll make it part of the materials, that you can use. You can tweak it however you see fit, but it's one way one individual can mandate that a provider disclose information to another person that's specifically recognized in the privacy rule. And then the last area is the area where there's the most of the questions seem to come up, discretionary disclosures, which in summary fashion I'll describe it. If the patient says, okay, you can talk to my daughter, there's no problem with that. If the patient is present and other people in the room and the discussion turns to protected information and the patient doesn't object, the provider can reasonably presume that the patient is fine with these other people hearing and can proceed. And thirdly, if the patient is incapacitated or not present, information can be disclosed if the provider determines, based upon professional judgment, that it's in the patient's best interest. And then they can disclose the minimum amount of information that is appropriate for the situation. There's some breaks on how much they can disclose. So there's lots of discretion here, and this tends to be where a lot of problems come up because different healthcare providers, have been educated to different extents under the Act, and people have different biases, and it sometimes requires a lot more negotiation, and that's because professionals are given a lot of discretion in this particular situation. Discretionary disclosures, as I said, are limited to just the information the person needs to know. And for the 20-plus years that HIPAA has been around, it always seems to me that HIPAA sanctions, when there's been enforcement, have always been targeted at the failure to preserve privacy, and hardly ever were people sanctioned for failing to disclose information, and it seemed to be very one-sided. But as I understand it, Rachel and I had a discussion the other day, and from the kind of issues that are arising and the statistics that they keep, that's changing, that there are sanctions for failures to disclose information. Is that correct, Rachel?
That is correct, Charlie. As you had mentioned, the right to access seems to be one that's less well-known and recognized under HIPAA. And a few years ago, we had our first significant civil money penalty case with a healthcare provider based in Maryland who was also operating a small health plan that was going out of business. And when the patients came to ask for a copy of their medical record, the provider refused to provide them with access to a copy of their record. We had roughly 70 complaints from various individuals regarding this provider, and it was a very difficult case, again, our first CMP case, but illustrates the fact that this is a very real issue for individuals. We receive approximately 17,000 complaints a year, and the right to access ranks right up there as number 5 of our top 5 types of complaints that we get under HIPAA. So we have been doing a lot of work to educate stakeholders, consumers, and others about their right to access and how having a copy of your health record can be a powerful tool in managing your care. And we'll talk a little bit about that in a few moments.
Rachel, there's one other thing I wanted to ask you as I was going through my slides, and I want to go back to the slide on pathways. I summarized these pathways for disclosure of protected health information, PHI as it's often referred to in short. But there are special rules that I wanted you to address about psychotherapy notes. What are those rules?
That's right. So there are very few limitations of what type of information a patient or their personal representative can obtain. And individuals are not able to access their psychotherapy notes, and this would also hold true for their personal representatives. But that is really one of the very few exceptions to getting a copy of your information. For instance, you can't be denied access for not paying your medical bill.
But if a provider feels comfortable disclosing your psychotherapy notes, they can do that?
This is, if they felt comfortable, I suppose so, but this is one of the limitations under the rule.
Okay. Let me go back to where we left off here, and I'm going to turn it over to you, Rachel, to pick up the slides from here.
Very good. So as I had mentioned earlier, we've been doing a lot of work in this area to make sure that our regulated industry, stakeholders, consumers are aware of the right to access under HIPAA. For professionals, we have issued a series of guidances, a comprehensive fact sheet that was rolled out in the early part of last year, and a series of robust FAQs. I think there are 52 of them that are topical and address the scope of the right to access, the form and format and manner of access of how an individual can obtain a copy of their information, timeliness, fees, and the ability of individuals to direct a copy of their information to a third party, and certain other topics. So let's go through some of these quickly. The scope of the right to access is we're addressing information that's held within what we call a designated record set. This is a very broad term, but it includes medical payment and other records that are used to make decisions about an individual. It doesn't matter how old the PHI is, where it's kept, or where it originated. But an individual can have access to all of this information, and it includes clinical laboratory test results and other underlying information, including genomic information, which really is an emerging piece of health information. So with very limited exclusions and grounds for denial, again, the scope excludes psychotherapy notes. It excludes information that's compiled for litigation separately from the designated record set. It excludes records that are not used to make decisions about individuals, such as certain business records, but underlying information like, again, genomic information remains accessible. A covered entity may not require an individual to provide a rationale for their request or deny the request based on a rationale offered. And again, no denial for failure to pay for healthcare services, and this holds true over time. Also, concerns that an individual may not understand or be upset by the PHI is not a sufficient reason to deny access. So next, let's talk a little bit about requests for access. A covered entity may require a written request for access. It can be done electronically, such as via a portal. There may be reasonable steps to verify the identity of the individual and or their personal representative, but this process of verification, the process of the request for access, cannot create a barrier to or unreasonably delay access. For example, a covered entity cannot require an individual to make a separate trip to their office just to request access to a copy of their medical record. Let's briefly discuss form format and manner of access. An individual has the right to a copy in the form and format in the manner that they request, as long as it's readily producible. So, if PHI is maintained electronically, at least one type of an electronic format must be accessible by the individual, such as a PDF. This also depends on the capabilities of the individual to obtain that information, not willingness. So an individual might request a copy of their information by paper. They can request a copy by email or mail, including, and this is important, an unsecure email if requested by the individual, plus a light warning by the covered entity about what the security risks are. So for example, if Charlie asks me, Dr. Rachel, for a copy of his PHI by email to his Google account, I might warn him about the security risks, especially if he doesn't have a firewall and if the email is unencrypted, but I can't deny him access to his information based on his request. Also, other modes are accessible if it's within the capabilities of the entity and the mode would not present an unacceptable security risk to PHI on that covered entity's systems. A few words about timeliness and fees. Access must be provided within 30 days. The department does allow one 30-day extension, but the expectation is that entities can respond much sooner, particularly if the information is kept in a patient portal. Limited fees may be charged for a copy. These are reasonable, cost-based fees that are limited to labor for copying and creating a summary or explanation if that's applicable. It could also include costs for supplies like a thumb drive or a CD-ROM and postage. No search or retrieval or other costs are allowed, even if authorized by state law. As you may know, oftentimes state law supersedes HIPAA, and many state laws are more permissive when it comes to timeliness and fees. Entities are also strongly encouraged to provide free copies, and many states do mandate free copies of records to individuals. Also, the covered entity must inform the individual in advance of the approximate fee that an individual or their personal representative can expect for a copy of their information.
Rachel, can you, going back to that slide,
yes,
say a little bit more about when the federal law preempts state law with regards to fees and when state laws can allow high fees?
Sure. Sure. Again, fees are limited to being reasonable and cost-based for labor, but the federal government does not set the floor for fees. This is done by state law through the state medical licensing boards, et cetera.
So they could have a per page cost set by the state?
Yes, yes. You may see a different fee per state, especially for organizations or individuals that might be working with Virginia, Maryland, D.C., for instance, across state boundaries. Another important note, though, related to fees is related to electronic copies of EPHI, electronic protected health information. So this is limited to information that is electronic, not paper. So we suggest a flat fee for electronic copies of PHI that are maintained electronically, provided that the fee does not exceed $6.50, inclusive of all labor, supplies, and applicable postage.
So just to be clear, if a person has a 1,000-page record, getting hard copies could be pretty expensive on a per-page fee rate, but if their records are also, same records are kept electronically, there is that limit on what it can cost.
Yes, and many times there is no fee at all. Many covered entities, laboratories, et cetera, now have a patient portal where individuals can go and grab a copy of their lab results, their clinical summaries, et cetera, and pull down a PDF and print that out at their home or have a friend do it for them.
Right. Yeah, we've seen that really ballooning in recent years.
So let's talk a bit about third-party access to an individual's PHI. This is an important one for this audience. Individuals' right of access includes directing a covered entity, this is a provider, the hospital, the health plan, to transmit PHI directly to another person in writing, signed, and designating the person and where to send a copy. An individual may also authorize disclosures to third parties, whereby a third party can initiate a request for PHI on their own behalf if certain conditions are met. Again, having an authorization in place that the third party is designated by the individual. If that's in place, again, a third party can initiate a request to a covered entity on an individual's behalf. So let's talk a little bit about sharing health information with family, friends, and caregivers under HIPAA. We have extremely robust guidance on this, and when we talk in a little bit about resources, I'll show you where to find that information. HIPAA sets rules for healthcare providers and health plans about who can look at and receive an individual's health information, including family members, friends, and caregivers. HIPAA ensures that individuals have rights over their information, including that right to access, the right to get a copy of their information, make certain it's correct, and know who's seen it. That's called an accounting for disclosures. When health information may be shared under HIPAA, a healthcare provider can share information face-to-face, over the phone, or in writing. A healthcare provider or a health plan may share relevant information, and again, Charlie had gone over this earlier. It's important to say it again, though. A provider or plan can have that information when they've been given express permission to share information by an individual or personal representative, when the individual is present and does not object to the sharing of information, and if the individual is not present or if they're incapacitated, the provider determines on professional judgment that it's in that person's best interest to share that information, again, with a family, friend, or caregiver.
Rachel, can I ask you one question there?
Yeah.
Because this comes up a lot in this context. It's very common for people, they heard a friend is in the hospital and they go to the front desk and say, is Mary Smith a patient here? What happens in those situations?
Yep. So if the family member, caregiver, or the individual has signed an authorization that allows their information to be included within the directory of individuals who are within the hospital, then the covered entity is allowed to not only confirm that the individual is staying at the hospital, but they can also receive some very limited information. This is type of information that you might hear in the media, that an individual's condition might be good or fair or in serious or critical condition.
That would usually be on the...
Yep, but again, the individual needs to have signed an authorization to have this information be included in the hospital directory.
Which would usually be on the hospital's HIPAA form.
Yes, correct.
Right.
So if an individual wants their health information shared with family, friends, or a caregiver, they have the right to do so. HIPAA requires covered entities to protect that information, the privacy and security of that information with specific safeguards. However, if an individual does not object, a healthcare provider or a health plan may share relevant information with family members, friends, and caregivers involved in the healthcare and or payment of healthcare in certain circumstances. Let's talk about some examples here. So we just talked a little bit about hospital scenario. So let's say an emergency room doctor may discuss an individual's treatment in front of a friend when a friend is asked to come into the treatment room. That information should be limited to the reason why the patient is being treated and not disclose other secondary conditions that aren't relevant to the reason why the individual is in the emergency room. A hospital can also discuss a bill with an individual's daughter who's with the patient and might have a question about the charges if the individual doesn't object. A doctor can discuss the medication of a patient with a health aide who's come with the patient to his or her appointment. A nurse may not discuss a patient's condition with his or her brother if he or she tells the nurse not to. And HIPAA allows healthcare providers to give prescription medication, medical supplies, x-rays, and other healthcare items to a family member, friend, or other person who picks them up. And this holds true for pharmacies.
You know, Rachel, one of the issues that we hear about a lot are caregivers who feel that they aren't getting enough information either while the person's in the facility or at discharge when they're being sent home. And it's interesting, there are a few states, and there's even been federal proposals that would require the identification of who the caregiver is, and presumably would spell out some specific guidelines on release of information to caregivers. I think that's going to be an ongoing issue for some time. But the other kind of situation we hear about a lot has to do when the healthcare provider, you may walk into the emergency room or you may walk into the patient's room in the hospital, and if the provider doesn't quite know what your relationship is or your involvement, they're often, I think rightfully, reluctant to release any information unless the patient is aware and can say that's fine. And so there is this implicit obligation for providers to get some understanding of exactly what your relationship is. You may walk in and say, well, I'm their agent on their power of attorney, but there's none on file and you don't have one to show them. They're not going to necessarily presume that you have all that authority. So eventually the kinds of problems we hear about all eventually get worked out at the end, but people can be perturbed by the hoops they have to jump through to get to a resolution of it.
That's right. It is very important for a provider to know that they have the discretion to use their best judgment to share information with the family member, caregiver, or friend who might be with a patient. And especially for this context, oftentimes the patient really isn't able to communicate. And when we were planning for this call, I used an example of how years ago I took my grandmother who had very advanced Parkinson's disease to the dentist. It turned out that she needed a root canal and couldn't speak because of her condition. And they came out and got me. There was no personal representative or there was no form that had been filled out saying that I could make healthcare decisions on behalf of my grandmother. But the dentist used their discretion. We made a couple of telephone calls, and my grandmother was able to get the care she needed. But again, the information that I was given was limited to the particular procedure she needed.
Mm-hmm. I think that's very, very common.
So what happens when an individual is not able to ask for permission? This again goes into what I was just discussing. If an individual is not present or cannot give permission, then the healthcare provider or the health plan representative can use their professional judgment about sharing information in the patient's best interest. And we give a couple of examples here. When the patient has an emergency surgery and is still unconscious, a surgeon could come out and tell the spouse about a patient's condition or share information by phone while the patient is still unconscious. A doctor may disclose medications with a caregiver who might call the doctor with a question about the right dosage. That's a really important one. And the doctor may not tell a friend about a past medical condition or problem that's unrelated to the patient's current situation.
Rachel, when one runs into a problem with getting information that they feel they need, a caregiver or a family member, in dealing with a hospital, they should know that the hospital has to have have a privacy officer. Can you talk about what the hospital's obligation is, or what
Sure.
routes for resolution may be available if you can't work it out with the healthcare professional face-to-face?
Sure. So you mentioned the first channel, which should always be the covered entity's privacy officer. No matter how small a covered entity is, no matter how large they are, they all have a designated HIPAA privacy officer. And that should be your first point of contact for troubleshooting or getting a resolution to your problem. Many of these problems revolve around access to health records. And then, of course, you can pick up the phone and call the HHS Office for Civil Rights and file a complaint. We have a 1-800 number. It's 800-368-1019. Again, 1-800-368-1019. Like I said, we get about 17,000 complaints a year. So really, we really try to advocate that working out the problem at the very front line, getting past the records folks, getting past the receptionist or the healthcare provider, and asking to speak to the HIPAA privacy officer. So we have been doing a lot of work, as I mentioned, to make sure that both consumers and professionals are aware of their right to access. Earlier this month, we launched a new consumer education campaign that we call Information is Powerful Medicine. Access to your health information is your right, and the URL for this is hhs.gov/get-it-check-it-use-it. And it really talks in plain language about an individual's right to access and how health information can be a powerful tool in managing your care. In addition to the poster that I just showed, it comes with a pocket brochure with an exterior and interior flap that talks about Understanding how your health history can help you ask better questions and make healthier choices. You can use this information to track your lab results and other medications, getting copies of your x-rays or other medical images, and how you can share that information with a caregiver or a research program. Inside the flap, you can see there's more information on Get It, which covers form and format and manner of access, time and timeliness, and fees, the main topics I just went through, but in plain language. Check It, how you can make sure that a copy of your information is correct and complete, and Using It. Again, the right to third-party access, including a caregiver or researcher. And this is a little slide, shows you a little bit of what the website looks like. It has links to all of our consumer fact sheets and FAQs, videos, a poster, a brochure that you can download for your practice to share with family members or an individual, digital ads and banners if you have your own website to bring people back to this information. And it's also all on a mobile platform, mobile first. So if you want to look at it on your smartphone, you could do so. And then there is a link there also to NIH's new precision medicine initiative, which is called All of Us. It's been a lot in the news today because they've just launched it. We also have a series of videos and infographics that we developed together with the HHS Office of the National Coordinator for Health Information Technology. There's a series of 3 short educational videos really geared towards healthcare providers, as well as an infographic that helps individuals understand their right to HIPAA, under HIPAA to access and get a copy of their health information. The topics are just the overall right to access, a separate video on fees and timing, and a separate video on the right to share your information with a third party. This is a little bit of the infographic. It's actually much broader than this, but again, plain language and trying to offer the same type of information that you would see on the video and fact sheets in a more graphic format. We also have a video on our YouTube channel that's specifically designed for family members and friends. The actors and portrayals feature older individuals, and it's really designed to help an older individual understand how they can share information with family, friends, and caregivers. There's a link there for our overall website for individuals on family members and friends, and you can see there's a link there to the video I was just talking about. Also on this website is one of our most popular pieces of guidance. This is a patient's guide when healthcare providers may communicate with you and your family, friends, or others involved in your healthcare. Much of the information that I just went through comes from this guide. If you haven't seen a copy of it, you can, again, go back to this URL that's in the slides and just link right to the patient's guide to the HIPAA privacy rule. And then those FAQs that I mentioned earlier, again, there's about 50 of them on the right to access, scope, limited exceptions, form and format, timeliness, fees, and the right to an electronic copy that's held in an EHR. You can access those off of our HIPAA for Professionals portion of our website. Our website is segmented by audience, one side for consumers, one side for professionals. And you can find us at www.hhs.gov/HIPAA. We also have a privacy and security listserv, and I really recommend that you sign up for it. You can get all types of topical information for instance, we've been pushing out information over the past 6 weeks on guidance related to all of the hurricanes and a special waiver for states affected by Hurricane Harvey, Irma, and Maria that's extended, allowed for a waiver for certain penalties and sanctions under HIPAA. So with that, I think we're going to wrap up and turn it over to Sari for some Q&A.
Great. Thank you so much, Rachel and Charlie, for a great presentation. We have some questions that have come in. And the first one that I'd like to ask you relates specifically to people with dementia. So one of our participants asked, if a person who has dementia doesn't recognize their caregiver and they tell the healthcare provider that they don't want them to discuss their condition in front of that person, what can the caregiver do in that situation, or what is the health provider able to do?
Well, that's a question where capacity becomes an issue. If it may, the person asking for information may ask that a consultation be done to assess the person's capacity. Of course, the provider doesn't have to do that, but if there's a reasonable question about their capacity or whether they're experiencing delirium, I think you would probably get a reasonable response. But if the person has capacity, then they control the situation. If they're determined that they're lacking capacity and they're really acting, delusionally, or they don't really understand what they're being asked when they ask the question, then you get to the point where they would be treated as someone who has the inability to consent or refuse consent, and then the rest of the HIPAA rules would click in. But it all centers around that determination of capacity.
Great, thank you. Anything else you want to add, Rachel?
No, that was great. Thank you, Charlie.
Okay. Let's go to a lot of questions about that same issue that you just responded to even more fully and answered a bunch of the other questions that are here. Here's a question came in from a geriatric care manager who has some clients with dementia that don't have family and don't have capacity, and the primary care physician doesn't want to make that declaration, so the client is still making decisions for themselves. Can you talk a little bit about how that geriatric care manager can share information so that perhaps this person can get better care than what they're getting in their incapacitated state?
I'm not sure I fully understood the question. The physician does not want to share information because of why?
The physician doesn't want to make the declaration that the person is incapacitated. So the client is still making decisions for themselves, while the geriatric care manager has made the decision that, or not decision, has seen that the clients don't have that capacity to do so. The question is more, how can they share the information, the geriatric care manager, with the primary care physician to get this information to them to help the person with dementia be better cared for?
So the physician, it sounds like the physician is assuming that the patient's refusing to give consent. I mean, if that's the case, it's similar to the first answer I gave, and it would depend upon getting an objective assessment of their capacity. And frankly, most primary care providers don't have a lot of training in assessing capacity, so they're not necessarily the best people to do it. For the care manager, there may not be any problem in their sharing information with the physician about the person's functional level. So information going that direction shouldn't be a problem if I understand the facts correctly. Rachel, is there any part of this you think I'm missing?
No, great job, Charlie. Thank you.
So can you talk a little bit about the difference between the kind of information that can be shared with a family member under HIPAA versus what can be shared with a durable power of attorney for healthcare?
Well, when you say general power of attorney, that can mean many variations of a power of attorney. The power of attorney, its requirements would be set by state law. So one really has to understand what their state law requirements are. And for health decisions, many states allow you to include the power over health consent and refusal of consent in a general durable power that even covers property matters too. But many states don't let you do that. You have to do a special healthcare power of attorney, and it has to meet the requirements of the Act. But if the state law, whatever form it permits you to designate authority over health decisions, if you've got a proper form in your state, then the provider has to treat you as if you are in the shoes of that patient if the patient lacks capacity. Now, if I give you a power of attorney to make health decisions for me, and I'm still perfectly capable of making decisions, the provider's got to listen to me because I control the roost as long as I have capacity. It's only when I lack capacity that the provider has to turn to the surrogate. So in some cases, it can be much like the previous questions. Well, has the power of attorney kicked in yet? Does this patient really lack capacity? There are a number of states also, I should add to make it more complicated, that allow you to give an immediate health care power of attorney, which means that the agent is kind of co-authorized while you still have capacity to do things for you, as long as they're within your knowledge and you're okaying it. You have kind of this continual veto power. But and I have used powers of attorney for healthcare to allow somebody who is a helper to have access to information at the same time that the person still has enough capacity to make decisions themselves. So this is really a state law issue, and there are at least, three variations. One, do you have to have a specific healthcare power? Can it be a general power? And two, can it be immediately effective, or is it only effective upon the finding of incapacity?
Great, thank you. Question for both of you. Do either of you have, through the ABA or through the Office of Civil Rights, a listing online about the various different power of attorney rules and that information, the state-by-state rules, so people can refer to that?
Yes, we do. On our webpage, we do legislative tracking in a number of areas, and we do have a comparative statute on healthcare power of attorney laws, which do include whether or not they can be immediately effective or not. And our webpage, I wish I had it up on the slide, apologize for that, is simply americanbar.org/aging. americanbar.org/aging. And then you go to resources and you look for healthcare decisions. And there's several resources under healthcare decisions, including legislative charts.
So I just want to get to this one last question because it came in a few times. There was a little confusion or clarification needed about who can access psychotherapy records. Can the person's representative get the psychotherapy records? Can the patient get psychotherapy records? There was a little bit of confusion on that.
No, those records are excluded from the right to access.
And there was the question of why. I'm not sure if you can answer that in a few seconds, but there were some questions of why that might be restricted or exempt.
I don't think I can get into it within a few seconds, but suffice to say that this is one of the very few pieces of the legislation that are exempt from an individual being able to access.
Okay.
But I would still add that a provider can agree to allow you access to some or all of your records, depending upon their assessment of whether that would be deleterious or not.
And I should say this only holds true for HIPAA-covered entities. So many therapists and psychotherapists and other providers in this space are cash-only business. So if they are not doing any of the designated HIPAA transactions like healthcare claim or enrollment, disenrollment in a plan, they're going to be, they won't be a covered entity, and then these rules will not apply. There may be state laws that apply, but HIPAA only comes into play when a healthcare provider is doing one of the designated electronic transactions.
Great, thank you for that clarification. Well, we are at the hour, so I want to thank you both again for your great presentations, and thank you to all the participants for joining us today. And we look forward to checking out all the great resources you provided to learn a little bit more. So thanks, everyone, and have a great rest of your day.